My name is Stephen Ipp, and Michael Swanson is to my right. You should have with you a copy of a handout of a set of slides and a separate single pager. If you don't, we can get one to you. Tonight's presentation, as you're obviously well aware, is on the subject of trusts in the context of insolvency, with a particular focus on the recent High Court decision in the Amerind. The way in which Michael and I have structured tonight's presentation is that I'm going to try and deal with some of the more practical issues that you'll be asked to consider when advising on trusts in insolvency, and Michael is going to focus on the Amerind and the fallout of that decision. As an introduction, in my experience, I often go to Bunnings and say, I'm going to go down for half an hour, and I come back about 3 hours later with an armful of tools to help ensure that your experience with the law of trusts is a bit like my experience at Bunnings. We aim to provide you with some of the necessary tools to guide you through some of the common trust issues that you'll face. At the outset, the context in which we are giving this presentation is when there are competing claims, usually between trust creditors and trust beneficiaries, but also commonly between trust creditors and general creditors of the company. In terms of the starting point, one must obviously start with the trust deed. The problem that many of you will no doubt have experienced is that your client often doesn't have the trust deed. If you are in the position that you do have the trust deed, the immediate focus ought to be on understanding what are the trustee's powers in the context of insolvency. That issue is usually straightforward if there's no ipso facto clause in a trust deed. And by that, I mean a clause which operates that upon the company going into liquidation, the trustee is removed. We have given each of you an example, or two examples of ipso facto clauses, and you may have seen them or looked at that before we started. I'll come back to that in a moment. But just returning to the first scenario, which is probably the easiest scenario to deal with, where, as I said, there's no ipso facto clause, and a liquidator is appointed to the trustee company. The liquidator continues to have the powers to deal with trust assets as the trustee company had prior to the company going into insolvency. The complexities and problems arise, as I said, when the ipso facto clause is evident in your trust deed. That circumstance occurs when the trustee company goes into liquidation. The company ceases to be trustee of the trust, and the former trustee ceases to have powers of sale. So you're faced with the problem where there are assets, but there's no power to deal with them. The issue is, how do you get that power? Now, there are a number of solutions that are commonly applied in this circumstance. The slide that is in front of you identifies 3 of those common solutions. It's typical that all 3 of those solutions will apply in the same set of facts, so that you will, for example, apply to court for the liquidator to be appointed receiver of the trust assets, and you will also seek directions under the trust legislation that the liquidator is authorised to sell trust assets, and you'll also seek a direction that the liquidator is justifying on relying on his or her statutory powers. The solution that is the most common is the first one. That is to apply for the liquidator to be appointed receiver of trust assets. And why that is done is because the liquidator, as I said, doesn't have the power to deal with the trust assets, and the liquidator's got to find some way to ensure that the liquidator can enforce his or her lien over the trustee's right of indemnity. So it's a way of protecting the liquidator so that he or she can deal with trust assets and be paid from those trust assets. One of the recent decisions which you also, most of you no doubt will be familiar with, was the full federal court in the Jones and Matrix decision, commonly referred to as Kalani, where the full federal court discussed in detail many of the issues that we're talking about. And if any of you are looking for a first point of reference into basic trust principles, I recommend each of the judgments in that decision because they are not only very interesting to read, but set out, I think, in a very clear way on what is a very complex issue of law. One of the things that Chief Justice Alsop said in the Kalani decision, His Honour discussed the task of appointing a liquidator as receiver, but His Honour made the point that it's not necessary to do that if the right of exoneration exhausts trust property after the sale of trust assets. Now, Michael is going to explain to you in some detail what the right of exoneration is, because that was really the principal topic of consideration in the Amerind. But essentially, what Chief Justice also was directing that observation to is that if after trust creditors have been paid and there's nothing left in trust assets to pay trust beneficiaries, there's no point in then making an application to appoint the liquidator as receiver. In terms of some of the things to think about when making the application to have the liquidator appointed receiver, I've identified two that perhaps at first glance seem fairly obvious, but in practice I think they're not. And that is firstly to give careful consideration to who the proper parties to the application need to be. And the best course is to try and join all necessary parties to the proceedings, and most importantly trust beneficiaries. Now, in practice, you will often find that you're having to make this sort of application in urgent circumstances because liquidator might have an asset and that the liquidator's got to try and sell very quickly to maximise the return to creditors. So things will be done, or need to be done very quickly. In that circumstance, you may not necessarily know who all the trust beneficiaries are or where they are. So it may not be practically possible to actually join them, but it's necessary to make those attempts and to give evidence of that in the application. If it's not possible to join all necessary parties to the proceeding, one should at least give notice to those persons by serving a copy of the application on them and giving them reasonable notice of the application. In the Kremen decision, which is also a very helpful summary of an application of this kind, Justice Mashinsky held that insufficient time was given to some of the necessary parties prior to the application first being made, and His Honour in fact adjourned it. I think it came back 5 days later or something like that to give all necessary parties proper time to consider it. So that's an illustration of what can happen if you are not able to give proper notice to all necessary parties. The the next slide identifies the type of evidence that one should aim to provide in an application. And appreciating, of course, that you're operating usually at an early stage of when you might have received instructions, and that you might not have had an opportunity to get all the information that you would necessarily want to get. But this is a sort of a shopping list of items that you should aim to get if possible. And if there are certain matters that are not clear, one should, I suggest, identify those to the court. What commonly happens is that a liquidator will be appointed to a company, and it may not in fact be clear whether the company is actually operating or has operated as a trustee company. The liquidator may have actually gone about conducting the winding up in the usual way, that is to sell assets of the company, not in fact knowing that the liquidator didn't have the actual power at law to do so. The law has provided a number of solutions for liquidators in that circumstance, and one of them is that orders can be made nunc pro tunc, which effectively authorise a sale of trust assets that has already occurred. I want to talk a little bit more about what powers a liquidator has when appointed receiver of trust assets. And I've identified in the slide that the primary power that the liquidator has is simply a power of sale. That's not enough because, for example, a liquidator will look to make a distribution to trust beneficiaries, for example, if possible out of trust assets. So you have to, in crafting your application, provide for the liquidator to have more powers. And the way to do that is to rely on the powers I've identified, namely for the liquidator to get the corporation's powers that a receiver has under Section 420 of the Corporations Act. And some of you may be familiar with those. There's a long list of express powers in the statute which enable, usually, of course, a receiver to take various steps. By obtaining this order, the liquidator in effect stands in the shoes of the receiver and gets these powers. Now, the flip side of that is that the liquidator acting as receiver now also wants to get the powers that a liquidator has under the Corporations Act. And the way to do that is to seek an order under Section 477 of the Corporations Act. And likewise, many of you will be familiar with the long list of items in 477 which provide for the usual powers that a liquidator has. Because a liquidator is operating in an environment of uncertainty, a liquidator will be concerned to protect him or herself from any liability in the actions taken in this context. One of the ways to do that is to seek directions from the court as to the proposed conduct by the liquidator. And I've identified two possible sources of directions that a liquidator might take in this circumstance. And the first one is that the liquidator is justified in taking certain steps to sell assets pursuant to the state trusts legislation. So, for example, the Trustees Act of New South Wales has express provision in it for the sale of trust assets. And similarly, it is common for a liquidator to seek a direction that the liquidator is justified in taking steps pursuant to Section 477. Now, what happens if assets have been sold, as I said, and the liquidator at the time of the sale was not aware that the liquidator didn't have actual power to sell. The court can sanction an unauthorised sale, and the power to do so is provided for expressly under the Trustees Act. And I think that the second option that I've identified, namely that the court can excuse an unauthorised sale, is particularly relevant to a liquidator because that has the capacity to protect the liquidator from future liability. So under section 1318 of the Corporations Act, if you go to court and satisfy the requirements of that section, the court can excuse that unauthorised sale and in effect provide protection from what is in effect a negligent act by the liquidator. So that hypothetically an asset sale has occurred, several years might come and go, a beneficiary turns up out of the woodwork and complains about the asset sale, saying that it was done obviously at an undervalue, or perhaps the process, there was no proper process, and claim against the liquidator. The liquidator's protection is under section 1318 of the Corporations Act. When making an application of that kind, it is critical to explain to the court why the liquidator sold the assets in the circumstances that he or she did. Namely, what information did the liquidator have at the time of sale about whether, for example, the company operated as a trustee at all, what were the terms of the trust. So in effect, to put all the information before the court so that the court can properly understand the decision making of the liquidator. If that's done, the court will almost always be sympathetic to the conduct of the liquidator. This slide deals with, I think, an issue that might have seemed an easy way out, but as it turned out, it's not. And that is, again, we're focusing on the power of a liquidator to sell trust assets. And in the Caneland and Gembrook cases, it appears that there was some perhaps forward thinking about how to deal with this question of absence of power before the company went into liquidation. And so that a matter of days before the company went into liquidation, amendments to the trust deed were made. And they were made, it's suggestive, for the purpose of giving the liquidator power to sell trust assets and then also recover remuneration for the work done in selling the trust assets. And the court ruled very firmly that the answer, that is not a proper solution. One can't circumvent the legal problems that I've identified by simply amending the trust deed. And if you do so, not only will that be unlawful, but you won't get your costs on any application in doing so. I want to turn now to the question of remuneration, and that's obviously a topic that will be very close to a liquidator's heart. And I know that Michael is going to talk a little bit more about the issue of remuneration as to how the High Court dealt with that in the Amerind. I'm just going to mention briefly that if the trustee company operates solely as trustee, the position is fairly straightforward. The liquidator is entitled to be paid his or her remuneration out of trust assets. The difficulty and complexity will arise where the trustee company carries out dual functions. I won't say any more, so I think Michael will want to say a bit more about that, and I'll leave that to Michael. The next slide for me is probably the most difficult issue to find clarity on in the cases, because it's, in my experience, hidden away in judgments and fairly obscure. And it's in my experience, the issue is not well understood by practitioners, and that is what approval is necessary for the remuneration of a liquidator acting as trustee. And I think that a common view is that one can simply rely on creditor approval if you follow the practice set out in the Insolvency Practice Schedule, namely get a resolution from creditors or a committee of inspection. Well, that I suggest is incorrect. And when a liquidator is acting as trustee, it's mandatory when seeking approval for remuneration that the liquidator must seek court approval for that. The reason for that is that in that circumstance, the liquidator is acting pursuant to the court's inherent jurisdiction. And that's quite different to the jurisdiction that applies when a liquidator is seeking approval for remuneration as liquidator. In that circumstance, the jurisdiction that operates is the Corporations Act. So I think that's the clearest way to isolate these concepts in one's mind. One is the liquidator is acting purely as trustee, or one is the liquidator is acting as liquidator in the traditional sense pursuant to the powers in the Corporations Act. In terms of a court-appointed receiver, court approval for the remuneration of that receiver is required. So again, you might be faced with the circumstance where a liquidator has performed work as a liquidator and has performed work as a receiver. Now, for the work done as receiver, you'll need court approval. And I've discussed the question of disbursements in this slide and suggest that it's not necessary to get court approval for disbursements. But I think the interesting point that comes out of this in the case, the Gondon 5 case, is that even if you don't need court approval for disbursements, the receiver's got to exercise his or her independent mind as to whether or not to pay the disbursements. And in that case, a court-appointed receiver was appointed. The receiver went and engaged his own lawyers, and the lawyers went off and did a whole number of things which the court subsequently found were not really required because the beneficiaries who were the principal parties to the dispute had their own lawyers, and their own lawyers could have done the things that the receiver's lawyers did. So there was a doubling up. And so what then happened is that the receiver was then faced with the problem of being liable for the disbursements that he'd incurred, namely his own lawyers. So what did he do? He sent his own lawyers' fees out for assessment. So I'm sure that is not the preferred outcome. Those are the matters that I want to address in terms of the practical issues. I'm going to hand over to Michael now, and he's going to talk to you about all things Amerind.
Perfect. I say thanks very much to Stephen for entrusting Amerind to me, and I've been told that that's the only pun that I'm allowed tonight. So you've been the beneficiary of that, and I'm going to get in trouble for that second one afterwards. But Amerind is a great example of high-octane litigation in trusts and insolvency field. It kind of really delves into the theory underlying trusts and underlying insolvency, and it is an exceptionally simple case in terms of what's happened, which has allowed the High Court to go into some quite factually complex, quite legally complex matters. And the most important part of this is that it's excellent for theory and it's terrible for telling you what to do in the future. I take a slightly less pessimistic view than a lot of people do on Amerind, that if you're working off the base of the theory that they have, there's a pretty reasonable, educated guess you can make as to where you need to go next, and hopefully I can give some pointers and some accurate guesses of what the High Court or a Court of Appeal might say the next step for this is. But on the other hand, there isn't a lot of practical assistance that does fall out of Amerind. So the most important thing you need to know as background for Amerind is that Amerind is the company that went into liquidation, had the sole function of being the trustee of a trading trust. That's all it did. So it had no external debts, it had no other functions. All costs it incurred were costs of the trust and incurred on behalf of the trust. And thankfully for us, that makes it very simple. As you can see, it had certain debt facilities with a bank which were secured by fixed and circulating interests, sold them off, satisfied itself of all of its debts, and there was a surplus of about $1.6 million left over. And the question arose as to what the hell do they do with that? And this gave rise to a dispute between the Commonwealth, who claimed that they should be paid that $1.6 million in preference to another trust creditor for it. So those two had a fight out through the Court of Appeal and all the way up to the High Court. My favourite part about Amerind so far that I've managed to find, though, is that it was cited by Justice Derringer in a very substantial judgment. It sat at about paragraph 120 or something like that, the very next day after it was handed down. So I hope for his honour's sake that was a judgment handed down at 4 o'clock and not at 9 a.m. that morning. I haven't yet to see another case from the High Court to be cited so quickly in a substantial judgment. So credit to Justice Derringer for that. Now, the most important aspect, and possibly the most practical aspect, that falls out of Amerind is this concept of the right of indemnity. And the court takes care that it breaks it down into two separate rights. The first is the right of exoneration, which is what Amerind dealt with, and the second is the right of indemnity, which Amerind deliberately didn't deal with. But everybody made a couple of sly comments on it, perhaps suggesting that the High Court would like someone to run a right of indemnity case up to them so they can have a bit more of their say on this issue. So the right of exoneration, as was dealt in Amerind, is a relatively simple concept, and it's pretty easy to understand. There's trust property, and where a debt is owed by a trust creditor, that money can be paid straight out of the trust property by the trustee. That is, there's no intermediary between the two, there's no trustee's own bank account, there's only a bank account held on trust, and money is paid out of that. Hopefully you can see from my wonderful little diagram that it is a simple concept, and that's important. And the second one is the right of recoupment. And that is where a trustee pays a trust creditor out of the trustee's own assets. So you have a simple stage, you have two stages then. The first stage is there is a trust debt that is owed to a trust creditor. The trustee pays that out of their own assets, and then they go to the trust assets of some variety and they take the money back out of that and it goes back into the trustee's bank account. So the signs when you might see something like that is when a trustee holds, the only thing a trustee holds is an asset which is not liquid, it might be a house or a painting, but requires maintenance as a way of example. So there are ongoing costs. So there are costs legitimately incurred in maintaining the trust property as is necessary. So they are, the persons to whom those debts are owed are trust creditors with trust debts, but there is no trust assets from which the trustee is able to pay that money out of. They pay it out of their own assets. Now, this distinction is important because as people practicing in insolvency, this has a great effect on where the money can be paid to and how parties have access to it. So the important question I think arises out of this is who can I pay money to, and if you're acting for a creditor, who can pay me what kind of money? So the right of exoneration, as was dealt with in Amerind, is the simpler concept of this, and that is only trust creditors can be paid money out of the trust assets. So where you have, say, a trading account held on trust by the trustee, and there are trust creditors, you head into liquidation, trust creditors can take, the money can come straight out of that trust asset and can go straight to the trust creditor, and that can be satisfied ideally in full, but on whatever pari passu or priority payment comes out of there. Whereas, as we'll come to in a second, the position for the right of recoupment is slightly different. The important thing to note is that where you are dealing with a trust that is acting, or a trustee that's acting under the right of exoneration, that money cannot be used to pay non-trust creditors. So it can't be used to pay for creditors of the trustee itself. acting independently of the trust that it's set up. So you can start to see where that brings in a bit of more complexity than we had in the Amerind case. Importantly, in Amerind, the High Court dealt with two cases. The first was one re N Hill from the Victorian Court of Appeal. And in a brief summary, it essentially said that that trust property, being property legally vested in the trustee, is available to distribution to any creditors. And it dealt with the South Australian Supreme Court case of re Suco Gold, which took the opposite position that the High Court eventually agreed with, that only trust creditors can be paid out of the trust assets. So a little bit of South Australian pride there. Coming from there, I always like it when they support a good South Australian decision, especially over a Victorian one. And it keeps me out of trouble when I'm in New South Wales and I say that to everybody. So excellent work by the High Court there. Next is this right of recoupment. And this wasn't dealt with by Amerind, but everybody, the two pluralities and Justice Gordon all make varying degrees of reference to it, and essentially suggest that this is going to be substantially more complex and it's going to be substantially more difficult for everybody to deal with. As I just was discussing before, essentially you have a two-stage process with the right of recoupment. That is, the trustee pays the debt out of their own assets, and then that debt to the trustee is paid out of the trust assets at a later time. Now, that time could vary between, seconds, or it could vary between years. It's not really material how long that time is, because those rights of indemnity and exoneration are different. And the real danger that falls out of this is if you have a company that has been acting and paying money out of their own assets to satisfy trust creditors, is that when that debt comes in from the trust, and that the trustee will always have the right to recoup that full amount from the trust, that money then becomes available to all creditors who have access to it. So if you're acting for a creditor, it might increase your pool. If you're acting for a liquidator, it might make things a bit more difficult. As I'm going to touch on as we go, this might have some significant problems and some substantial litigation when you couple that with liquidators seeking priority payments or preference payments or director-related transactions and clawing that money back, in that you may have trust creditors essentially falling in line with every other creditor of the trustee company and not being able to rely on that money coming directly out of the trust to only satisfy their debt. I say that with some caution that the High Court and no appeal court has dealt with that issue yet, but they have flagged it as something we should talk about. And for all these things, if you'd like to have a slightly more detailed look at it, I commend everybody to Justice Gordon's judgment in Amerind. Her Honour goes a bit further in discussing the practical aspects of it and dealing with it in a matter that provides a bit more guidance than the rest of the court did in that aspect. So it's well worth a read if you're faced with a bit of a problem. So to go from the simple to the complex to the ridiculously complex, expressed in as simple a way as I possibly could, I promise, where you have a trustee that is acting as, or a company that is acting as trustee of separate trusts. So it applies to 2, it applies to 100, it applies to 1,000. This scales depending on your number and how silly your client is in putting 1,000 trusts in a single company. But the direction that we can pull out of Amerind here, first on the basis of the right of exoneration, and that's that trust creditor has direct access to the trust assets to satisfy its debts on liquidation, and a liquidator can pay out there. And so the way that this should be dealt with in the first place is for any person stepping in as a liquidator or as a creditor attempting to give directions to a liquidator is to insist as forcefully as possible that separate funds are set up for every separate trust. It sounds like there might be some extra costs incurred in doing that, and it might create a bit of extra work, but this is the safe way to avoid commingling funds between various trusts and starting to step on rights of exoneration which only exist in the first trust as opposed to the second trust or the third trust or the fourth trust. So the biggest takeaway, I think, from anything I will say is please set up lots of different funds for everything, because it's going to save everybody a lot of time and pain in the future. And once you establish your separate funds, if you treat each one as you would as if there was just one trust, you end up in the same position where you have before, and you ask yourself, is this trustee acting under their right of exoneration? That is, can I access the trust assets directly to pay trust creditors, or have they been using their own assets to make payments to trust creditors, and are we in the territory of the right of recoupment, and all the issues that follow and flow from that. And this touches on, as Stephen suggested before, the liquidators or receivers' remuneration in here. Now, Justice Gordon made some indication that the general rule should be that because as the liquidator, you're only allowed to take the assets available to you from the trust when you're dealing with trust debts, that insofar as you can apportion the actions of a liquidator and the costs of them from one trust to another, that should be done so. And if you set the way you're dealing with this up first, and that you've got separate accounts for everything, it should be relatively straightforward. If you're in the unfortunate position that someone before you has come in and started commingling assets or commingling debts and liabilities and issues, it starts to become more complex, and it's not really possible in that case for people to account individually. So this hour was for Trust 1, this hour was for Trust 2, and this hour was for Trust 3. And the direction from the court, Justice Gordon in the High Court there, is that the High Court is likely to fall back on the concept of equity as equality and just apportion asset and just apportion costs evenly across all trusts. Now, that's important to keep in mind of if you're dealing with trusts of varying size in terms of assets, because if you are apportioning your fees equally across all of them, you'll end up with some trusts easily being able to cover them, other trusts being unable to cover them, and you yourself might start to fall a bit shortchanged when you're dealing with those smaller trusts. And again, if you can set up everything individually and separately, you find yourself in a much safer position being able to account for all of your assets. So something to bear in mind, especially when you are dealing with multiple trusts, even ones that start to commingle before you come in. Now, which trust assets you can use to pay is an important question, because it really comes down to, well, if I need to sell something, what can I sell first and what should I sell first? Now, both the right of exoneration and the right of recoupment arise out of the trust relationship between your trustee and the trust property. So the first step is always going to be to check that deed and see what that has to say. Fortunately in Amerind there weren't these difficulties, so we did have a reasonably simple case, but it's easy to see circumstances perhaps wherein a trust doesn't permit a trust deed doesn't permit assets of the trust to be charged with either fixed or circulating securities, as they could in Amerind. You might start to run into some difficulties of what assets you can and can't start to access. But assuming your trust deed is silent as to what you can and can't do, the second answer to this really does appear to be that it's to the discretion of the trustee or the person acting as the trustee. And the reason for this is that the right of indemnity, particularly the right of exoneration, attaches individually to the product, to the asset, that being that the trustee or the person acting as the trustee has an equitable right that is in priority to the beneficiary's right to the trust assets. That applies across the board unless it's contradicted by the trust deed. So that starts to come down to the discretion of the trustee, their right in equity being greater than the right of the beneficiaries across the entire property. The reason this might be important is some assets might be substantially easier to liquidate than other assets, and cash may be needed in a quick amount of time. Now, in any event, to keep yourself safe and to keep yourself out of litigation, first step should always be to consult the beneficiaries, get everybody on the same page, make sure everybody's at least relatively agreeing from it, so hopefully to avoid yourself a fight. But at the end of the day, my opinion on this is that there is a trustee discretion on what they can and can't sell. There may need to be some justification as to why that is to the court. As in all circumstances, limitations are often placed on these kind of discretions in that they still have to be in the best interest of the beneficiary, and they need to be reasonable in all the circumstances. Now, probably the most important thing to fall from Amerind was in what order do I pay everybody, and quite thankfully everybody was in furious agreement in the court about this, which makes our life easier. and that is really that your usual priorities under the Corporations Act in terms of your priority payments apply to payments out of trust assets on behalf of a trustee. They apply to both receivers and liquidators, and you take your normal steps that you follow through them. You check the legislation, you check who falls in priority according to that, and you pay them out in that way. At the end of the day, I don't think this was a particularly controversial issue that the High Court needed to solve, but it was the ultimate issue that flowed through them, and their finding was pretty resounding. And really the question here for us is, Amerind has decided, but where do we go to next when we're faced with a problem that doesn't really fall into, neatly into the category of Amerind? And the court, in everyone's judgment, in both the pluralities and in Justice Gordon's judgment, really took this purposive reading of the Corporations Act. Some of them went so far as to say there has been this right in equity for years that employees get paid out before a circulating interest does. We find this in a lot of cases in the Corporations Act under Section 433, Section 556 or 561, and they said that they will interpret the Corporations Act and they will interpret powers consistent with that. So your question that you need to ask yourself when you're dealing with new issues is, what is the purpose of the priorities that the Corporations Act is set up and the general law recognises? And my opinion is, with this High Court, a good guide as to what they will do next and to what the correct answer is that look at that purpose and apply that to the set of facts that you're doing. The High Court doesn't seem keen to let people set up companies or trusts in a way that lets them skirt around paying out these priorities. If you're smart enough to find a way that can do that, you've managed to prove to the entire world you're smarter than at least 4 High Court justices. So I think you deserve a good medal for that one. But it's going to be difficult to do, and this really needs to be the way that you approach problems that arise that we haven't dealt with yet. Is, what is the purpose? Why are these priorities there? And how has what I've done tried to affect that? And how do I apply these purposes to it? So you're likely to find in most circumstances that the court is going to be erring on the side of whatever setup you have, however the trusts are established, you should be paying out the priorities found in the Corporations Act. Again, the caveat to this is, as always, there is no binding decision on this yet, but this really is, this really kind of, in my opinion, was through the entire Amerind judgment, and really should be seen as the backbone of what fell out of that. So the purposive approach to the Corporations Act is the way that we approach interpreting insolvency law and trust law in this area. Now, in Amerind, there were 2 plurality judgments, and Justice Gordon, who agreed with Her Honour Justice Bell's majority in that. And the one point where they differed was in determining what constituted a circulating asset. So Chief Justice Kiefel plurality considered that the right of exoneration, that is, the shows in action that vested with the trustee to enforce an equitable right that existed in a piece of property, is what constituted a circulating asset, and that the liquidators the receivers could call on that right as a circulating asset in and of itself to pay out trust creditors. Now, the Bell plurality, with which Justice Gordon agrees, considered instead that it was only the equitable right that existed in the trust property which was the circulating asset. And it took me a while to kind of try and work out in my head what that distinction was and what it really meant, because it doesn't necessarily on its face seem to be a huge difference. I mean, if one has an equitable right, one must have a shows in action in order to enforce that equitable right. One flows from the other. But where that might start to cause a problem is where you have circumstances where a trust doesn't let you charge trust assets with circulating or fixed securities. And the reason for that is that on my reading of the Chief Justice Kiefel's majority, you could invoke the shows in action in the right of exoneration to do that. But where you aren't able to invoke that right as a circulating asset, if the asset itself isn't circulating asset and subject to a charge, you might find yourself in a bit of difficulty enforcing that as property. And whether or not that falls under Section 433. So I mean, that's a piece of litigation for time to come, although it's relatively settled now as to what you should consider it to be relatively settled as to what the position is, and that is it attaches only to that equitable right that exists in the property, not necessarily just to that right of exoneration. It's a bit slimmer, I think, than the Chief Justice Kiefel's plurality decision. I've touched on here some of my own thoughts on what I think the future litigation in this area might touch on. In particular, we're definitely going to see circumstances with varied trust structures where you have companies with multiple trusts, companies that sit within a series of trusts. In theory, you should be able to follow these principles that are set out in Amerind and make a determination as to what you should be doing and where everyone's rights lie. But as I'm sure everyone's aware, people do strange and creative things when they're setting up trusts. People have strange ideas about how to set up series of trusts to protect themselves. So without a doubt, there's going to need to be litigation to sort out how we sort through these problems, although all of it will be based on the theory set out in Amerind. Amerind also doesn't touch on priority disputes amongst individual creditors within the priority list of the Corporations Act, but it seems to me from the decisions in Amerind that they will follow the normal disputes process, and one should have at least some bit of confidence reading a general priority dispute in the Corporations Act and applying that to a priority dispute amongst trust creditors to a trading trust. Undoubtedly, we'll see that litigation come through at some point, but I think we've got at least some clarity on what the answer to that will be. And personally, I think the most interesting one, so if it comes up, please send me briefs on it, is how this is all going to interact when we have the right of indemnity being exercised by a trustee and we have preference payments claims being made or unfair, uncommercial transaction payments being made. This is when we're going to see trust creditors having their money come back into the trustee, whether or not trust assets exist, and then there's going to be a fight then about who takes priority over what money, whether that clawed back money can be assigned a priority to trust creditors over general creditors of the trustee, and that's going to be cause, I suspect, for substantial litigation going through to the future. So those are my observations on Amerind. Are there any questions that have arisen for either myself or Stephen out of our wonderful and insightful presentation on trust tonight? Stephen, do you have any non-pre-prepared, non-consultative questions that you'd like to put to me?
I just want to confirm that Michael said he was going to tell you lots of jokes about trusts. I said they were all bad jokes and I wasn't going to allow it. Michael disobeyed that instruction and then put my name next to his on the title page of the first slide. So all responsibility for Michael's bad humour should lie with Michael. But that aside, we attempted to add some levity to what can be at times a little bit dry by introducing some little comments on the back of your one-pager. So that's designed to show you that we at Greenway have a sense of humour, or we like to think that we do, and you can decide which of those memes applies to you personally. In terms of questions, that is Michael and I, anticipated that it might be a little bit difficult to think of a question immediately that would come to mind. And in that environment, I asked myself and Michael, where do we go from here? And one of the things that came to my mind is an observation that one of the many commentators has made, is that the issues in Amerind are not new. They've been in existence, obviously, through the law of trust for hundreds of years. And when you go back to Hill and Risico Gold, we're talking, 3 decades. The other interesting thing that I thought of is that when you look at the cases that have come out recently, there's now a great deal, many cases dealing with these trust issues. But the interesting thing is, I think there are a lot of new trustees suddenly being written out there. What's happened is that people are understanding that their obligations and how to deal with the issues that arise with these trustees, and they're now coming to court to get the court's approval for the things that you need to do in dealing with trustees. So I thought that was, in my mind at least, quite interesting. With that aside, I thought I'd ask Michael if he had any view, given what he said about Amerind, as to whether there's any prospect for law reform on any of the issues Michael's discussed. Over to you, Michael.
My completely off the cuff and in no way whatsoever pre-prepared answer to this question is I think the main area in which there's actually nothing written on this page. The main area I think in which law reform is available and should be looked at is dealing with the concept of multiple trusts and intermingled assets. It's clearly going to be the hardest problem that falls out of Amerind and that falls for people dealing with liquidators and receivers dealing with trust assets and trust companies. As I was saying before, trusts are, as Stephen just said, trusts are always built in new and wonderful and magical ways. Every time you see a trust company that comes before you, I'm sure it is different, more complex and less easy to deal with than the previous one before you. And dealing with assets and liquidation is something that we as a legal system have decided is highly regulated and highly legislated. And in that context, there needs to be someone who puts their mind to setting out a series of rules that both legal practitioners and non-legally trained liquidators can follow in order to deal with multiple trusts and commingled assets. At the moment, there's just no direction on how to do that other than dealing with some very archaic common law principles that fall about trusts and about liquidation. The High Court makes comment in Amerind that there's no guidance even on this question that Stephen pointed out was around in 1983. There's been no legislative direction on that, let alone the issues of complexity of multiple trusts and commingled assets that are really going to fall from it. So if anybody is interested in writing to your local Member of Parliament or a paper on it, I think that would be very fertile grounds for law reform, and probably the most pressing question for practitioners everywhere really on it. I think that's... Is there anything from anyone in the wonderful audience today that falls out of that or out of interest? I think we're good.
We'd like to invite you to come and share a drink with us just over the other side, and thank you very much for your attendance.
Thank you, everybody.